I did want to rule on a motion that I took under advisement on Friday. I heard several motions that day, but the one that I had not ruled on concerned a blog post that the defendant wrote 11 years ago called How to Murder Your Husband. And we had heard testimony that the blog post had been written for a writer's workshop. Now, defense moved to exclude the blog post, and having fully considered the matter, I am going to grant the defense motion to the extent that the evidence is potentially admissible under Oregon Evidence Code 4043 as relevant for a non-propensity purpose to show the defendant's knowledge. I don't believe it survives the balancing test the court's required to undergo under Oregon Evidence Code 403. Any minimal probative value of an article written that long ago is substantially outweighed by the danger of unfair prejudice and confusion of the issues.
All right, so let's bring in, once again, criminal defense attorney Jesse Lal in Atlanta and former prosecutor and trial attorney Vonda Sargent in Seattle. Ultimately, you heard the judge saying it would be prejudicial to admit this essay, which was written 7 years before the alleged murder of the defendant's husband, the essay being How to Murder Your Husband. Do you think that's a big loss, Vonda, for the state?
I do not. Given her computer search, her computer history, the ghost guns, the looking for gun parts through eBay, I don't think that's going to be much of a loss for the state in this case. I think that Nancy Brophy's taking the stand is going to be the biggest loss for the defense in this case. So I think the state's case is solid, and it'll be interesting to watch this.
And Jesse, I got to pick your brain on this case a little bit earlier, and you know, you seem to think that the state has a lot of challenges, one of them being that the defense does not have a murder weapon here. What else do you think?
Well, first of all, I agree with Vonda. The knee-jerk reaction was, I mean, not the knee-jerk, but the typical reaction to that motion was, it's too old. The posting was really too old, and unless the state has some evidence that she kept rereading that essay and following the notes written in that essay, I mean it clearly outweighed. It was clearly outweighed by the prejudicial value of bringing in that noting. Yes, I still agree that the state has a huge, very steep uphill battle. There is no murder weapon. Other than the minivan being in the area with no identity of the driver. And these folks have been married for a long time. There's no indication of violence between the two, no indication of a very, very disruptive marriage, no indication of abuse. Yes, they are in debt, and so are millions of couples. There's a lot of insurance been bought, so do a lot of couples. And these facts in and of itself, I mean, it's a tough hill to convince a reasonable juror that she killed him beyond a reasonable doubt. I think the defense can make a very quick case of poking a lot of holes and creating doubt along the way. And yes, it would be my professional opinion, just on my brief review of this case, that having the defendant testify when things are going not so badly for her so far, would be not a very good thing.
That's very interesting. You know, certainly, I mean, and just to remind our viewers, Ms. Lal, you're a defense attorney, and Ms. Sargent, you're a former prosecutor, so I wonder sometimes if that might, inform the opinions.
No,
no.
We are completely unbiased. That's why you have us.
Oh, yes.
We're not taking sides.
No, we want to hear your opinion. We want to hear your opinion from your unique perspective. Vonda, I mean, I asked Jesse about this before. To me, the insurance stuff really those were major facts that were very helpful for the state, because, you talk about the fact that Nancy actually sold life insurance. She sold herself all 6 life insurance policies. She was a sole beneficiary of not only the 6 life insurance policies, but the workers' comp policy. Stood to gain more than 1.4 million on a year when they were $6,000 behind in house payments. They spent $16,000 paying the insurance. To me, I mean, you're got the prosecution background. What do you think?
Right.
Well, first of all, I mean, and just to remind our viewers, Ms. Lal, you're a defense attorney, and Ms. Sargent, you're a former prosecutor, so I wonder sometimes if that might, inform the opinions.
No,
I disagree with Jesse. I don't think that the state has a hard or a hard road to hoe here. I think the fact that she sold all of those life insurance policies and then paid them instead of paying their mortgage. And yes, millions of people are in debt, but the first bill you pay is where you lay your head every night. That just, it goes without saying. You pay where you sleep before you pay where you eat, before you pay for your food, because you have to have shelter. In addition to that, this individual, she wasn't quite truthful about the amount of money that she stood to gain. In fact, she said it was $45,000, which is significantly less than $1.4 million. In addition to that, she claimed that she was home all day. She has all these searches for gun parts, ghost guns, which is very damning, that you're looking not only for gun parts, but for gun parts that can't be traced. Had she just been looking for guns just in general, maybe just, had some curiosity, but a ghost gun, that is damning. The fact that she says she was home all day and her van was seen elsewhere. I don't think that you have to have a bunch of strife in a marriage or even a relationship for someone to decide, I'm done with you, and you are not bringing in enough money, or whatever the issue may be about the money, to want to no longer be with you and take your life. So I don't think that it is dispositive that there has not been a bunch of strife that we're aware of in that marriage. So I think the state has a very strong case, and it's going to be interesting because I think the defendant's going to take the stand, believe she's smarter than everyone else. She's a wordsmith, she's an author, and she's going to get up there and try to convince them, like she tried to convince the police, to write her a little note so she could get the money. So I think they're sunk.
It's very interesting that you mentioned that little note. The prosecution highlighted in their opening statement that note, that kind of odd exchange that the defendant had with police after her husband died. Let's listen.
Right.
I don't want to do, but this may give you a laugh this afternoon. I don't want to be the stupid question of the day, but I think I need to be the stupid question of the day. So my insurance company said, well, just have the detective write a letter that you're no longer a suspect. And I said, man, I just don't know that he's there. And I'm not sure that he looks at it that way. But if you do, I'd get you to write the letter. My sister, when I told her this as a lawyer, laughed so hard she fell out of the chair. So
why
because
why would you need that?
Because they don't want to pay if it turns out that I secretly went down to the school and shot my husband, because I thought, hey, going into old age without Dan after 25 years, it's really what I'm looking for,
Okay. Well, we never would do something like that. I
really didn't think so.
Yeah, I mean, that's not something that we never do something like that. That's never been done. I've never heard of that being done.
Okay, Jesse, so if you're an expert defense attorney, how do you explain that?
Right.
This is a woman who uses a certain phraseology to say, look, this is what my insurance company wanted. I'm just going through the process of collecting on insurance due to the death of my husband. How many people have not done that? I mean, there is no waiting period. There is no, but if she's, apparently this is a homicide investigation, and the insurance company have given her this instructions, and she's told the officer exactly what the insurance company has told her. Why should I derive from that conversation that she's a suspect, that she's a strong suspect? In most homicide cases involving couples, they always say the partner is the suspect. Okay, fine, but the state has to prove it. The state has to prove that this woman got the weapon, was at the scene, and shot him twice in the back of the head. And clearly, she has never had experience with guns before. She's never shot someone before. And there's nothing in their marriage to indicate that she's capable of doing something like that or driven to do something like that. The circumstantial evidence is, the status quo, the template that the state uses to try to get an individual convicted. But it's going to be up to the jury. I just don't think we are there right now. But, you know, jurors have surprised me in the past.
Mm-hmm. Yeah, sure. Okay, so Vonda, you know, we've been talking about the life insurance policies, right? Nancy says actually that she had a health scare, so she took out those policies to protect her husband because she loved him so much. Now, the defense actually wants to submit some racy text messages showing that the couple maintained a physically intimate relationship as well. You know, they were very passionate about each other, I guess, is what they're arguing. How do you think that kind of evidence plays with a jury?
Yeah, I don't think it's going to make any difference one way or the other. I think that this defendant is going to present as an individual who thinks she's smarter than everyone else. That phone call with the detective, he was laughing because her request was laughable. She sells insurance. She knows how insurance works. She knows that that is not how insurance works. You don't get a note when you're a suspect for murder from the investigating entity to say that you're no longer a suspect to collect on the insurance. So these racy text messages, I don't think it's going to matter one iota. And going back to what Jesse said about that one instance of this phone call, that's just one of the many layers that the state's going to use to paint her as the murderer, the person who committed this crime. So it's not going to rest just on that one piece of circumstantial evidence. And states try cases on circumstantial evidence every day. Circumstantial evidence, it has the same weight as direct evidence, and the jury will be instructed. This is the same as if someone actually saw her raise the gun and shoot her husband in the back of the head twice. The circumstances that lead you to this conclusion are the exact same as if somebody saw her do it. So we get kind of caught up in this country, oh, it's just circumstantial evidence. It's the same as direct evidence. It has the exact same weight and the exact same impact as direct evidence. So I don't think that, you know, saying the word circumstantial lessens the weight of that evidence, one iota.
All right. You know, can I just say that you two are so excellent in your respective fields, playing the kind of role of prosecution and the defense.
Thank you.
You do such a great job of illustrating for I think our viewers the importance of how an adversarial system works.